Madam Clerk, would you call the next case on the docket, please?
State of Tennessee versus Justin Keith Willoughby.
Good afternoon.
Good afternoon, and may it please the court. My name is Catalina Goodwin, and I represent the appellant Justin Keith Willoughby. With permission of the court, I'd like to reserve 5 minutes of my time for rebuttal. The trial court abused its discretion by denying judicial diversion to Justin Keith Willoughby, a young first-time offender who pulled himself out of a broken home and was a decorated law enforcement officer at the time of the offense. The standard of review of a sentencing decision is abuse of discretion with a presumption of reasonableness. No presumption of reasonableness applies in this case because the trial court did not articulate the basis for granting probation, but not for diversion. Because a trial court, by definition, abuses its discretion when it makes an error of law, and the trial court here committed several legal errors, this court should apply de novo review and grant Mr. Willoughby judicial diversion. The trial court found that Mr. Willoughby was eligible for diversion, and that is not an issue here. And while on the record, the trial court considered all of the Parker electroplating factors, it committed legal error when it weighed several of those factors, including amenability to correction, deterrence, and the circumstances of the offense. I will return to those errors, but would first like to discuss the trial court's arbitrary finding as a whole that probation, but not judicial diversion, was appropriate in this case. As this court is well aware, the factors for probation and judicial diversion are the same, but their concepts and underlying purposes are distinct. And the trial court is ordered to analyze the issues separately and differentiate between the two. Here, the trial court found that Mr. Willoughby was a good candidate for for probation, and it found that the threat of confinement was sufficient punishment for this case. But that reasoning applies with equal force to judicial diversion. While Mr. Willoughby is not statutorily entitled to diversion, he is statutorily entitled to be considered for it. Judicial diversion gives eligible offenders like Mr. Willoughby the chance to avoid a permanent criminal record. By denying judicial diversion based on irrelevant factors and incorrect legal standards, but granting probation under the same factors without articulating a non-arbitrary reason to grant one but not the other, or explain the underlying purposes of judicial diversion, the trial court deprived Mr. Willoughby of his state and federal constitutional protections of due process. If the trial court had actually considered the purposes of judicial diversion and articulated those policy differences between it and probation, it would have granted diversion and given Mr. Willoughby this second chance, as we are asking you to do so today on de novo review.
How does that work in reverse, Ms. Goodwin? If a trial court found that someone did not qualify for judicial diversion, would they automatically not be a good candidate for probation?
Could you rephrase your question, Your Honor? I apologize.
So you're saying since the factors are the same and someone denies, let me withdraw that question. That is making no sense as I'm hearing it come out of my mouth the second time.
Well, it's not. I mean, to the extent that I think you're on to something.
I'm trying to articulate something and it's not coming out.
What was curious to me about the argument is that it seems that you're suggesting that if you are eligible for diversion and the diversion factors weigh in your favor, you should be granted diversion. Two, that if the court doesn't grant diversion but finds that you're an appropriate candidate for probation or an alternative sentence based upon the same factors, you should have been granted judicial diversion, right?
I do understand your question, and that's not, I don't mean to imply that just...
Judge Hickson is saying, well, what if the reverse is true? What if on the alternative sentencing question I conclude that you should be in custody? Does that always mean you should be denied diversion?
Probably not always, especially with how fact-intensive our sentencing is here in Tennessee.
So is it the case here that simply that this court had no basis at all, that it was wholly unreasonable to say, I don't find you're an appropriate candidate for judicial diversion, but also don't think you should be confined?
No, Your Honor. In this case, the trial court didn't articulate why Mr. Willoughby was appropriate for probation, but not for diversion. And
you have different factors, though, when we're talking about custody. So not only do you have just the regular Trent factors that you would consider for alternative sentencing, but they're also considered in light of 4035-103, right? That
right.
Incarceration is meant to for people with a long history of criminal conduct, the need to avoid depreciating the seriousness of the offense or to provide an effective deterrent to others, or where lesser means have been tried recently and have been unsuccessful. Those are all factors that you consider in a custodial determination that you don't consider in a diversion determination. So it's entirely possible that considering some of the same common law factors, you could come to different conclusions about the propriety of diversion and whether you should have a custodial sentence, right?
Yes, that's right.
Okay, so how did the trial court not do that here?
So here, the trial court went through all of the electroplating factors at one time to consider both diversion and probation. It determined that probation was appropriate, but without discussing the policy purposes behind diversion, which is so that a eligible candidate can avoid the stigma and collateral consequences of a long-term criminal conviction. Because it did not articulate those things, that is why the presumption of reasonableness does not apply here, and why we are entitled to de novo review. I'd like to now address...
Both of these, and let me go back to it and just
Yes,
press just gently back on this. These are separate questions, right? So the question of judicial diversion is a separate question from alternative sentencing. I think that the Supreme Court in King said that you would be entitled to an abuse of discretion review if the trial court identifies the electroplating Parker factors, discusses the relevant ones on the record, and weighs them and comes to a conclusion. And I think that happened here with respect to the judicial diversion determination, did it not?
The trial court did weigh all of the factors in this case.
And I understand we're saying that maybe the trial court weighed them inappropriately, or maybe it applied factors that maybe shouldn't have been applied, but the court did identify the correct standards and attempt to weigh them, did it not?
It did, Your Honor.
So are we not under an abuse of discretion standard then with respect to judicial diversion?
Procedurally, the trial court's issue isn't about whether or not he weighed the factors. He did. He laid out every single one of the electroplating factors, and I have errors that I can deal with later about the individual way that he weighed those. But the difference is that the trial court does need to put on the record for this court's review why one and not the other. And he did not explain why judicial diversion was not appropriate, but probation was in this case. And because that information was not on the record, that is why I submit that we are appropriate to review this under de novo.
So let me ask, if I can restate the argument back to you to make sure that I have it. In considering judicial diversion as a trial court judge, to obtain an abuse of discretion on standard review on appeal, I need to consider the Trent factors. I need to place my reasoning on the record with appropriate weighing. My decision needs to be consistent with the purposes and principles of sentencing, and I need, plus factor, and I need to discuss why, if I grant an alternative sentence, that I granted probation and denied diversion. I have to do that extra step to get abuse of discretion on the judicial diversion consideration?
Abuse of discretion would apply anyway, is my understanding, Your Honor.
Okay. All right. I'll let it go. I wonder, what I'm hearing, I think you say, is that to get to get de novo review, the trial court also has to articulate why probation was granted but judicial diversion was denied. And I don't see that extra factor in any of our case law when we're talking just about judicial diversion.
Your Honor, if I may suggest another way that we can go into de novo review.
Sure.
Here, a trial court always abuses its discretion when it makes an error of law. You see this in Kuhn versus the United States. And the legal errors that the trial court made with respect to individual factors, including amenability to correction, deterrence, and the circumstances of the offense, because of those legal errors, including adding arbitrary requirements onto the defendant, such as apologizing directly to the victim, those were legal errors, and that is also another way that we can move ourselves into de novo review in this case. On the amenability to correction, the trial court found that that factor weighed against diversion because Mr. Willoughby had not accepted responsibility. In this case, Mr. Willoughby did accept responsibility for causing the victim emotional pain. He entered a best interest, no contest plea. He agreed to stipulated facts in that case, even though stipulated facts are not required for a no contest plea. He demonstrated his remorse and acceptance of responsibility in a letter to the court and in his allocution statement. And he also showed it with how he turned his life around. During the pendency of this criminal case, Mr. Willoughby's life fell apart. He was depressed, and he spiraled into alcohol abuse. He then completed 3 months of intensive treatment in Pikeville, Tennessee, and turned himself around before sentencing. The trial court legally erred by determining this was not enough. He claimed that Mr. Willoughby had not shown remorse because he had not apologized to the victim directly, because he had not listed the victim's name in his discharge plan from treatment, and neither of those things are required for acceptance of responsibility. Mr. Willoughby consistently demonstrated that he understood the gravity of his offense, that he understood that he caused the victim serious emotional pain in accordance with this with the aggravated assault that he's been convicted of.
Where is that in the record? Is that was not in the allocution, so was that in a separate document?
His expression of remorse is found in the letter that he wrote to the court, which is in volume 1 on page 67. Mr. Willoughby says, I accept full responsibility for my conduct and the harm and potential harm that my actions have caused. I fully and honestly regret every aspect of the situation. He also said it again in his allocution statement at the trial, and that's in the transcript in volume 4 on page 55, lines 5 through 9. I feel shame, regret, and embarrassment for the things I have done. And he later says, I'm sorry to Ms. Grider. The trial court found...
Do you agree, and I'm sorry to interrupt, do you agree that if he had not acknowledged that he had caused the victim in the case emotional or psychological harm, that would weigh in favor of a finding that he was not genuinely remorseful?
It would, Your Honor, but in this case, he did agree to the stipulated facts that he caused emotional distress, and I do believe that the record is sufficient to show that he demonstrated his remorse in apology to and without directly apologizing to the victim, which is not a requirement for acceptance of responsibility or amenability to correction.
Do you think it's a relevant factor, though, in terms of remorse? So, for example, as I was reading the statement in allocution, the defendant identifies his mental health issues, his alcohol addiction, his loss of relationships, his suicidal ideation, his relationship with God, his active participation in church, his active participation in a rehabilitative program, his employment, his fatherhood, his apology to his family and the court, an apology to anyone I've had contact with, and then he says, I'm sorry to the victim. And then he ends it and says, I need the chance to rebuild my life. In that, I think the trial court took from that he was essentially self-centered, had not focused or acknowledged that the victim had suffered emotional or psychological harm. And at least in State versus Ailey, a case from this court in August of 2019, we affirmed a denial of judicial diversion, at least in part on the absence of remorse under circumstances like that, where this court said the defendant expressed regret that he put himself, his family, and his friends in a situation like this, but he didn't acknowledge that he endangered the victims emotionally or psychologically. And it strikes me that that's pretty similar to what we have here. So how, if Ailey is appropriate, how is this case distinguishable from Ailey?
And Your Honor, I'd appreciate an opportunity to review Haley again and provide some post-brief after the fact. However, in this case, here, Mr. Willoughby did apologize to the victim, and I know that it was a minor part of these statements, as Your Honor has pointed out, and the judge can certainly consider that, but it's not, there's no magic amount that any defendant has to apologize.
So if the judge can consider that, and we're agreed that that's an appropriate consideration, then it also must be up to the judge to determine how much weight to give it.
I agree that he can consider it, but in this case, the trial court put undue weight on it as to Mr. Willoughby's case. Moving to how the trial court erred as it weighed general and specific deterrence, and this also ties in with the interests of the public. The trial court expressed its need to send a message to the law enforcement community as a whole to prevent officers from being rehired after committing an offense based on its own personal observations and assumptions of the court that officers will reoffend in a new uniform when hired by another agency. This was an error. There's no evidence in this case that the law enforcement needs this kind of general deterrence. Mr. Willoughby was not a law enforcement agent at the time of the offense, and it's the trial court's musings also assume that an entire class of individuals, law enforcement officers, will reoffend if they get rehired in another agency, which goes against the policy of judicial diversion, which is to have a second chance.
I thought was he not working in uniform as a officer for the school?
He was a security officer at the time of the offense, but he was not a law enforcement officer at the time of sentencing. And
So are you saying that if you work for a university in a law enforcement capacity, you're not a law enforcement officer? Or am I misunderstanding what you're saying?
I'm not saying that, Your Honor. No, my argument here is about how the trial court used general deterrence toward the law enforcement community at large as a reason to deny judicial diversion.
But the guy he was post-certified, wasn't he?
Yes, Your Honor.
And was he not sworn as an officer for this from the school?
He was, but Your Honor, what...
So I guess I'm trying to understand what you're making the distinction with.
Yes, well, Your Honor, the trial court used
It may not be that big a deal. I just was trying to understand what you were
No,
saying.
I understand it. I mean this as it pertains to general deterrence and the public interest. That is how the trial court brought up the law enforcement issue. He wanted to send a message to the law enforcement community by denying diversion in this case. And I am out of time. I do ask that you reverse the trial court and grant judicial diversion. Thank you.
May it please the court, Catherine Redding on behalf of the state. I'd first like to turn to the probation issue. I just would like to clarify that, yes, as an initial matter, probation and judicial diversion are separate concepts. Yes, they are both taken up as sentencing, but they serve different purposes. Judicial diversion, as we know, is a legislative largesse that kind of exceeds the largesse of probation. Second, the defendant has not challenged the imposition of confinement, the denial of probation in the brief. I'm not entirely sure that that's the claim now at argument, but if it is, that's waived. And I also did not understand the defendant's brief to say that the imposition of probation but the denial of diversion means that the denial of diversion is reviewed de novo. I understand, and having looked back at the brief, it's a separate due process claim. But I'll just point out that the trial court in this case did provide its reasons for denying probation. It obviously, the biggest issue, it went through judicial diversion first, considered all of the factors for judicial diversion, made its decision. After it said, I'm denying diversion, then it went on to probation. It specifically recognized that the defendant was a favorable candidate for probation, which is not something that exists for diversion, and then went through the confinement factors, did what this court has directed trial courts to do, considered, yes, there is an overlap in consideration, but when you get to the denial of probation and the imposition of confinement, then there are those three additional statutory factors, and it is clear that the trial court did engage in those factors. So if the court is interested in the denial of probation, I would ask for an opportunity to provide briefing on that, given that that's not raised in the briefs at the moment. But for these reasons, I can go into the due process claim, but it really just turns on the fact that these are two separate concepts. It is entirely possible for a trial court to say, you have not established that you are a good candidate for judicial diversion, and still find somebody is presumed a favorable candidate for probation and that confinement is not appropriate. So these things they're connected, but they are not intertwined, such that a denial of one means a denial of the other, or a grant of one means a grant of the other.
Though it's curious that the court seems to say that you use the electroplating factors for diversion, and then you also use the electroplating factors for probation.
Yes, I think there's a fair amount of overlap, but I think
Trent says they're identical.
Yes.
But Trent also wasn't discussing the additional factors in 4035-103. And so those are factors, as you point out, are additional factors that you consider in a custodial inquiry that you don't consider in a judicial diversion inquiry.
Correct. And the court made clear, I mean, I didn't go in, because it's not in the briefs, I really didn't explore this too much. But looking back at my brief, as far as believing that my brief accurately sets forth what is in the record, the trial court did engage in the 3 confinement factors, and it was those factors that really drove its decision that I can't order confinement here. You don't really have a prior record, like you haven't been on probation. So I don't think that the denial of probation really plays into this. So if you want to turn to the denial of judicial diversion, it's the state's position that the trial court sentencing decision is entitled to review for abuse of discretion and a presumption of reasonableness because the court did consider each of the common law factors. It specifically identified the relevant factors. It said, recorded its reasons for denying diversion on the record. It weighed the factors, and it just essentially concluded that the defendant was not entitled to diversion. Contrary to the defendant's assertion, the court did not consider any improper factors. The defendant, in his brief, focuses on the court's kind of observations about his apology to the victim in this case. But it's the state's position that considering the apology is appropriate because it comes up in the context of amenability to correction. So the consideration there is not an improper consideration. And its observations about the ability of law enforcement officers to be rehired and the demand for law enforcement officers. I mean, frankly, I can't tell from the record how much the court was just observing that the state had made this argument and how much it was adopting the argument, but it still comes, it's still relevant. It's not an inappropriate factor because it's part of, I think, both the deterrence and the public interest consideration.
Well, this court has recognized that with some professions, law enforcement being one of them, that a breach of trust that occurs in that type of capacity is something that will work to be a factor to deny diversion. Not by itself, but in connection with others. And is it true here that the defendant was that the defendant's actions with respect to the victim occurred in his official capacity? I mean, my understanding was she was reporting in an office. He was uniformed at the time.
I don't know how the victim came to be in his office, but the record shows that he was in his office on campus where he was a security officer and he was in uniform.
So if the actions here occurred while he's acting in his official capacity, then that amounts to a gross breach of trust as it goes. At least our prior cases seem to have recognized that, I think.
Yes.
Did the trial court here recognize that?
I think the trial court here was very concerned with the fact that the defendant held a position of public trust, that the defendant was in uniform, that this happened in his office. So it didn't, my recollection is that it didn't explicitly say, well, it did say you hold a position of public trust, but it didn't, you were on duty, you were in your uniform. Every student should be able to trust the law enforcement officers, the security officers, if you want to call them that instead, on their campus. It didn't take it to the next level, but it is very clear that the court was very concerned about that.
Okay, I'm sorry.
And that actually takes me into my next argument. So it's the state's position that the court's decision is entitled to review for abuse of discretion and presumption of reasonableness, and so this court must uphold the denial of diversion so long as there's any substantial evidence to support the decision. And it's the state's position that there is more than substantial evidence to uphold the decision. First, the circumstances of the offense do justify the denial of diversion. As I said, not only does the proof show that the defendant assaulted the victim and that she suffered serious bodily injury, it shows that the victim was a minor. She had just turned 16. The defendant was a security officer at her school. The offense occurred in the defendant's office while he was in uniform, and the assault was, the nature of the assault was that the defendant asked this barely 16-year-old victim to touch his penis in his office while he was in uniform. The defendant abused his position of trust as a security officer, and the victim's serious bodily injury was so severe that she tried to commit suicide, and she was hospitalized in a psychiatric hospital for 2 months, and the average stay, according to her statement, is a couple days. She was there for more than almost 2 months, I believe. So that kind of goes into the next point, where the defendant's arguing that the circumstances of the offense, that the court, they have to be especially violent, shocking, reprehensible, offensive, extreme, or exaggerated. But that standard doesn't apply here because the trial court relied on more than just the circumstance of the offense. And even if it did, it's the state's position that the circumstances of this offense are more serious, are egregious, than just the elements of reckless aggravated assault, the conviction offense. Moving on to the next point, the state's position that the defendant's lack of amenability to correction also supports the denial of diversion. I first point out that the defendant's strong R assessment resulted in a score of high violent, with high needs in family and residential, and moderate needs in employment, aggression, alcohol and drug use, and attitudes and behavior. Then if we move past that, it's the state's position that the defendant failed to accept responsibility for his actions. He did not have to admit his guilt. There is a distinction between admitting guilt and accepting responsibility. And taken in totality, in which part the apology, or I can't say lack thereof, but I can say the minimal apology to the victim is part of the totality of what was presented. I mean, when the court gets into the record, you will see the technical record with the defendant's application for probation is 3 volumes. And the defendant's apology to the victim is very small. But that's not it. That's not the end of it. It is clear that the defendant regrets the consequences of his actions. It's the state's position that the record does not show he actually regrets his actions. He regrets what happened because of it. And that is, from, as you pointed out, the effect on his life, the effect on his relationships, his employment, he's having to move in with his dad, with whom he doesn't have a good relationship.
I've heard it phrased sometimes that I regret the consequences of my actions toward me.
Yes.
I don't regret necessarily the consequences of my actions on others.
And I think that that's what the trial court was finding here. And I think that the record supports that conclusion. And even if we go to the defendant's his alcoholism, I mean, to first say, the defendant seems to have suggested that his alcoholism is proof of his remorse. But there's actually no evidence in the record to support that claim. And the defendant's own statements make it clear that he developed a drinking problem after all of the things happened to him, as a result of the depression and anxiety he felt when he didn't have a job anymore, when his fiance, cut their relationship short, and all these things happened to him. Then he spiraled into addiction. And I will say that he did seek treatment for his drinking. He does appear at the time of sentencing that treatment process was successful. But there's no connection between his drinking and and the offense. It's clear that he didn't develop a drinking problem until after he committed the offense. So yes, he might be amenable to correction in terms of substance abuse, but that doesn't really get to the matter, which is he had a 16-year-old touch his penis at the office, and he wasn't drunk. He didn't have an alcohol problem then. So amenability to correction for addressing your drinking problem doesn't really go to whatever happened where he asked a child to touch his genitals.
General, what do you make of the trial court seemed to reference, best I can tell from the briefs, that this could have been a different offense or a more serious offense, or it could have been an offense that required offender registration. Was that appropriate in your mind?
I think that in this case, there's definitely cases where it's not appropriate. I don't think that the comments that the court made here rise to that level, because it said, I have this in my brief, it says, I don't know that there's enough in the stipulation to say there's evidence that would have supported a conviction for sexual battery. So I think the court was concerned. I think that really goes to kind of the egregious nature or the exaggerated nature of the offense, that this is more than just a reckless aggravated assault. But it is clear that the court didn't hold the defendant to that, didn't require him to defend on that charge.
fact that someone, I'm not talking about this case, I'm just talking about in general, the fact that someone is charged with a particular offense and they plead to a lesser offense, but there's clearly evidence of a greater offense, a judge can consider that as a factor when making a determination about probation or alternative sentencing, I think.
And judicial diversion.
And diversion.
Yes.
There's case law that says that.
Yeah, so the distinction here in your mind is that the agreed stipulated facts entered at the no contest plea do not clearly make out the greater offense.
Correct.
Okay.
They don't clearly make out the greater offense, and I don't think the court really held him to force him to defend on that or punished him or said, because you could have. It certainly doesn't reach the point of saying you could have been convicted for this, so I'm denying diversion based on the fact that I think you should have been convicted or you should have pled guilty to a greater offense. I think it's making an observation about the circumstances of the offense, and it kind of just falls into that. I don't think that it reaches the level where it's an improper consideration or holding the defendant to some other, to defend on some other charge. As to deterrence, it's the state's position that there is more than a scintilla of evidence to support deterrence, general deterrence, not specific deterrence. The defendant did hold a position of public trust. He was a post-certified officer. He was working as a security officer at an institution of higher education. He was in uniform. He was in his office. He had a barely 16-year-old child touch his genitals. He asked her to touch his genitals. There is a need to deter law enforcement officers, public officials, school officials from engaging in sexual contact with children.
Okay, so you just said that, but you're saying, though, that the stipulated facts didn't say that.
The stipulated facts established that the victim was a minor, that she was in the school, and that he was in uniform and he asked the victim to touch his penis. So I think that that is enough there.
We don't know, so the touching is not mentioned, just he asked her to. So it's solicitation, not solicitation.
Well, he also, the last part of the stipulated facts is he admitted to having sexual contact with her in his office. So I think, the defendant never.
Some would argue that the stipulated facts raise a higher criminal charge than what he pled to.
And I think that's what the court was concerned about, is it seems like we're getting very close, but I think, going back to your question, Judge Hickson, I don't think that the court held him to a higher issue. I think that there is enough here that the stipulated facts get us to, in uniform in his office, intentionally asked a child.
Contact.
Yes, sexual contact.
I think Judge Montgomery's asking, it sounds like actually that the stipulated facts would make out a claim of sexual battery, aggravated sexual battery.
Particularly when you have somebody that's a minor.
And in that case, if he were convicted on that case, he wouldn't be eligible for diversion. And so is that what the trial court actually considered here, was that on the stipulated facts, there is proof of a non-divertible offense?
In that the court said, you've actually committed a non-divertible offense, so I'm going to deny diversion.
Right, was that part of the rationale?
No.
Okay,
No.
all right. So, the trial court didn't even go that far?
No.
Okay.
And I think the court's own statements were, I think you're very close, but I can't say for sure that you're there. But it certainly didn't say, I think you should have been convicted of this non-divertible offense, and I'm denying diversion because you should have been convicted of that. I
didn't read that anything that anybody said. I just was
I understand.
curious.
And then the last diversion factor that the state offers is the interest of the public. Granting judicial diversion to somebody under these circumstances, and I hate to repeat myself, but the uniformed officer at school, having a child touch his penis, having somebody here receive judicial diversion is not in the interest of the public. The public should be able to trust school officers, should be able to trust law enforcement, should be, frankly, able to trust adults generally. But here, the public has a heightened interest in its law enforcement officers, the security officers, people dealing with its children, to know that they are not going to have sexual contact with children. So granting diversion, granting diversion would not be appropriate. The collateral consequences of a conviction in that people can know that about the defendant's wrongdoing, and it would impede his ability to return to law enforcement. That is in the public interest. The defendant may have testified or said in his filings, oh, I don't plan to go back into law enforcement. But 10 years down the road, who knows? The public's interest is we should know that this person once held a position of trust in relation to children and violated that trust. That should be available. The public clearly has an interest in there. And further, we really have to take into consideration the extensive injuries that the victim suffered in terms of 2 months of hospitalization when a normal stay is a couple of days.
Thinking about a felony conviction and the ability to possess a firearm, obviously, if he was post-certified, he had the ability to do that while he was in uniform. Do you know if he had was there anything in the record to reflect whether he was armed at the time?
I don't believe that is in the record.
Okay.
I think it only goes.
Just curious.
I think it only goes to.
It's not really. I just was thinking about it out loud.
Sure.
So.
I don't think that comes up anywhere. As far as it goes, is I think just the uniform. No, I don't. It would be speculation to discuss what that uniform might entail. But as far as I know, that there's nothing there. If there are no further questions, the state asks this court to affirm the judgment.
Good afternoon. I have a few points of clarification. I'd like to start by discussing the nature of Mr. Willoughby's plea. Mr. Willoughby pleaded no contest in his best interest. He did not admit to any legal guilt. And while we've been calling these stipulated facts, and I have been as well.
Actually, I don't think you can do both of them. Either you plead no contest, or you plead best interest. If you plead no contest, you stipulate to the facts. If you plead to best interest, you say that the state, it's in my best interest to accept this plea, and I'm not going to contest or stipulate or agree to the facts that the state has.
In this
Unless
case,
I'm wrong.
the trial
There is a
court.
distinction between the two.
There is a distinction. You don't get both. You have one or the other.
In this case, the trial court did accept this
Now,
hybrid
in trial
plea.
court, you may have said a best interest no contest plea, but that doesn't really exist in the law.
What you're saying, though, is he did not stipulate to the facts. Is
That's
that right?
correct.
Okay.
Mr. Willoughby we entered facts into the record of this case. However, he did not admit any legal guilt. And if you look at the facts that are in the transcript, there's no indication that Mr. Willoughby knew that this victim was a minor. It says that he asked her to touch his penis, and that she did, and then she had emotional distress after the fact. The stipulated facts in
What was
this.
the nature, help me with this, because I'm sorry, I've forgotten. What was the nature of his employment?
He was
at
a
a school?
security officer
At
at a community college.
community
So
college.
she was a community college student.
She was a high school student taking advanced placement credits or something like that?
That's right.
Okay.
And so, Your Honor, something that my colleague said over and over again was about having a child touch his penis in his office. This was a college student at the time, and there are no stipulated facts about what he thought was going on. This case was very heavily negotiated between the parties, and the prosecutor determined that we were not going to resolve this on a sexual offense, and because the trial court was relying on these facts that it conjured up that were not in the facts that were presented on the record, that were based on inferences from the victim impact statement and Mr. Willoughby's own original charges in this case, which is an abuse of discretion and a clear error of law. Here, the trial court also stated that it was.
Are you saying for purposes of a judge considering the facts and circumstances of the case, that he cannot also consider the victim impact statement? Is that what you just said?
He can consider the victim impact statement. However, in this case, if you look at the victim impact statement, it's much more about the distress that she had after the fact, and reading in the sexual offense that he did in this case was inappropriate. This is similar to State versus Kilgo, where there as well, the trial court inferred additional facts from the victim impact statement to support aggravation. So by doing so, the trial court abused its discretion and committed a clear error of
So
law.
counsel, and just so that I'm clear from the
Yes.
record, so at the original plea hearing, defendant did not stipulate to the facts as the state announced them?
On page 15, lines 3 through 6, the judge asks if Mr. Willoughby is indeed not contesting the facts, and that is what it says on the record, Your Honor.
Okay, so he says, I'm not contesting those facts?
Correct.
He
It's not
agrees-
contested.
He agrees with the facts then?
I'm sorry?
He agrees, the defendant agrees with the facts?
To the limited stipulated facts, yes.
Okay. And in those facts, the facts themselves say that she was 16, do they not?
I don't believe they do.
Okay.
It says that she was a minor after the fact, but there's no indication that Mr. Willoughby knew that she was a minor, as opposed to another student on a college campus.
All right, fair enough.
I'd also like to clarify, one of the other purposes that came up was that law enforcement officers should be deterred from this kind of conduct. But law enforcement officers are not among the categories of offenders or types of offenses that are excluded from judicial diversion under the judicial diversion statute.
Was there any discussion about the amendment to that statute related to appointed public officials?
There was some discussion about that. However, Mr. Willoughby that was not applied in this case. And how the trial court handled that, it was not based on his status as an officer. It was in order to send a message to the community as a whole and prevent him from getting another job in law enforcement in the future. Upon de novo review, this court should recognize Mr. Willoughby's acceptance of responsibility and expression of remorse, as well as his efforts to rehabilitate himself, and grant him diversion on de novo review. Thank you.
Thank you, counsel. Thank you.
All right, Madam Clerk, would you call up the next case, please? Thank you all.
Thank you.
State of Tennessee versus James